This paper grew out of an amicus brief that Will and I filed in Franchise Tax Board versus Hyatt, in which a Nevada citizen in Nevada court sued an arm of the state of California. California said the suit violated a constitutional rule of sovereign immunity, and the U.S. Supreme Court agreed. But to us, that seemed wrong in two directions at once. First, the Constitution doesn't say anything, at least not explicitly, about what state courts can do to other states. And second, the Constitution does say in the 11th Amendment that federal courts like the Supreme Court can't even hear a lawsuit against California by a citizen of Nevada. So what's going on here? Why was the court inventing a constitutional bar that isn't in the text and ignoring a constitutional bar that is? Our claim, building off of work by Caleb Nelson and others, is that the courts have conflated a common law rule of sovereign immunity, a rule that predated Article 3, survived Article 3, and motivated the adoption of the 11th Amendment, with the constitutional rules set out in the amendment itself. Once you distinguish the two, once you put the common law rules and the constitutional ones in different boxes, then you realize most of the famous sovereign immunity cases really go in the common law box. And you can take the 11th Amendment to mean precisely what it says. And when you do that, you find it says some pretty surprising things. The 11th Amendment is a cross-cutting bar on federal subject matter jurisdiction in law or equity suits filed by diverse plaintiffs against U.S. states. That means, contrary to current doctrine, it can't be waived by the parties, can't be abrogated by Congress, and can't be ignored on appeal by the Supreme Court. It applies to suits against states, and only filed by diverse plaintiffs. To see how this works, let's start with the common law. So even before the Constitution, the states claimed immunity from compulsory process. This was a personal jurisdiction immunity. You couldn't make a state show up in court. And it didn't come from state constitutions or the Articles of Confederation, but from principles of general and international law. At the founding, people argued over whether these principles outlasted Article 3, which does provide for judicial power over controversies between states and diverse plaintiffs. And people like James Madison said it did. Just as the creation of alienage jurisdiction didn't mean that alien enemies could sue, and the creation of diversity jurisdiction didn't mean that married women could sue, like horrors, it also didn't mean that people could sue states as private plaintiffs just because there was a head of state diversity jurisdiction. Now, the majority of justices took a different view in Chisholm versus Georgia in 1793. But a lot of people at the time thought Chisholm was wrong. And if Chisholm really was wrong, this common law picture makes a lot of sense of a lot of the doctrine since then. So if, as in Hans v. Louisiana, a citizen sues his own state in federal court, the amendment won't bar the suit, but a common law immunity might. Or if, as in Seminole Tribe, Congress tries to abrogate that immunity, well, it needs some enumerated power to do so, which it might not have. Or if, as in Alden v. Maine, it tries to abrogate that immunity in state court, well, then it needs even more power, which, again, it might not have. Or if, as in Hyatt, Nevada tries to abrogate California's immunity, well, that doesn't have anything to do with Article 3 or with federal power, but the judgment might face other barriers to being recognized in other states. All of this is separate from the 11th Amendment, which applies only in federal court and only to suits by diverse plaintiffs against states. So what exactly does the amendment do? We think that the right way to answer that is to look at its text, which says, here we go, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So let's take that line by line. The judicial power of the United States. That is a restriction on subject matter, not personal jurisdiction. So 11th Amendment immunity is not waivable. The states can overcome a common law bar on compulsory process just by showing up voluntarily in court, but they can't waive a limit on the judicial power of the United States. And that seems like a deliberate choice, because at the time, a number of suits were pending in which the states either had voluntarily appeared or thought they had to under Chisholm. An unwaivable subject matter limit blocks any claim that these states, on purpose or by accident, had waived their immunity. But the common law immunity was still waivable, which is part of how the Supreme Court managed to mess this up. So 100 years later, in Clark v. Barnard, an in rem case where a state put in its own claim to the property at issue, becoming a plaintiff and not just a defendant, the Supreme Court said that 11th Amendment immunity was waivable, by analogy to the familiar personal jurisdiction limit, and it just sort of blithely stated that this applied to the amendment as well. From there, it was off to the races, with courts quoting Clark and assuming the 11th Amendment can be waived. But a lack of judicial power is never waivable, even if both parties want to be in federal court. Second, shall not be construed to extend. The 11th Amendment limits federal judicial power, cutting across all the heads of jurisdiction of Article 2. Now, some folks then and now have argued for what might be called a diversity theory of the 11th Amendment. It merely cuts off the state diversity provisions under which Chisholm had sued Georgia, leaving federal question cases and any other heads of jurisdiction cases intact. But the text of the amendment is cross-cutting. And while there are reasonable arguments on either side, we think the history actually bears out the more natural textual reading. So for instance, during the drafting, Senator Gallatin wanted to put an exception for treaty cases, and he voted against the amendment after his exception lost, suggesting that federal question cases, of which treaty cases are a subset, were not already excluded from the amendment's coverage. In 1798, in Hollingsworth versus Virginia, the plaintiffs openly argued that the amendment applied to federal question cases in appeals from state court in an effort to show that it wouldn't apply to their case. And in 1824, in Osborne versus Bank of the United States, the Supreme Court actually held that the state of Ohio didn't have to be joined to the suit, explaining in what it called a federal question case that the 11th Amendment barred making the state a party anyway. Now, one might ask why any of this was necessary. If all the framers wanted to do was overturn Chisholm and avoid an inference that the state diversity provision overturned the pre-existing common law immunity, why did they need to go after all the heads of jurisdiction? Why not limit the amendment just to the state diversity cases brought on state diversity grounds? And I think the most likely answer based on our research is that the amendment's supporters weren't trying to be minimalists. If you look at the records, they really, really did not like private suits against states. And they would not have wanted any negative inference generated by an amendment that said, you can't bring a suit against states in this particular situation that might suggest that maybe you could in other situations. I think the best example here, if you're familiar with the classic Christmas movie Die Hard, is in which one person is trying to cut the phone lines by using little wire clippers and going sort of clip by clip by clip. And meanwhile, Alexander Goodenough takes a chainsaw and just completely cuts all the lines at once. I think that's the 11th Amendment. It is cutting off a branch of judicial power with a chainsaw and not with a scalpel. Third, to any suit. The amendment is mandatory and exceptionless, and where the Constitution doesn't make exceptions, Congress can't either. Current doctrine says that Congress can abrogate the 11th Amendment by means of the 14th. This argument might work for the common law immunity. We can argue about the scope of the power there, but it doesn't work at all for the 11th Amendment, which is not a question of congressional power, but a limit on the judicial power of the United States. After all, Congress can't use the 14th Amendment to abrogate the 8th Amendment, imposing cruel and unusual punishments for people who violate civil rights laws, can't abrogate the 6th Amendment right to jury trial, can't abrogate the 4th Amendment and do warrantless searches of their houses. So why would we think the 11th Amendment is any different? The Supreme Court, even in its cases finding the amendment abrogable, doesn't really say, partly because most of those cases, in fact, don't implicate the amendment at all. They're about in-state citizens who the amendment doesn't cover. Once we separate the common law immunity from the constitutional one, we get different answers for each. Fourth, in law or equity. The 11th Amendment applies to any suit in law or equity, so it doesn't apply to admiralty suits. Usually that doesn't make too much of a difference. The common law immunity is still there. Most admiralty suits are in rem, but the Supreme Court should still get its act straight. In future drafts, we may be extending this argument to revisit the court's holding in Federal Maritime Commission versus South Carolina State Port Authority, which held that administrative agency proceedings were close enough to lawsuits to be covered by the constitutional immunity, if not by the 11th Amendment itself. But agency proceedings aren't suits in law or equity, which might take them outside the 11th Amendment, and they may or may not involve the kind of compulsory process that would put them in the common law immunity box. In any case, they're not covered. Fifth, commenced or prosecuted. The 11th Amendment applies on appeal, including on appeal to the Supreme Court. In Cohens versus Virginia, the court correctly held that a case is commenced or prosecuted by the plaintiffs, not by the defendants. So if a state is seeking relief, then the amendment doesn't apply. And if the individual is seeking relief against a state, then it might. Unfortunately, in the last few decades, the court has changed its mind, held in a case called McKesson that no matter who filed the suit originally in state court, the Supreme Court can always hear the case on appeal because its review of state courts is, quote, inherent in the constitutional plan. As Justice Souter noted in Seminole Tribe, that argument, quote, makes no sense, unquote. The constitutional plan is something you get from looking at the Constitution, which the whole point of the amendment was to amend. But he, Justice Souter, and every other justice then joined the opinion in South Central Bell Telephone explicitly reaffirming McKesson. This was wrong. The Supreme Court, like every other federal court, only exercises a portion of the federal judicial power. And if the 11th Amendment says that the judicial power does not include a particular suit, then the Supreme Court can't hear it however much it wants to. That point was raised in Hollingsworth versus Virginia in 1798, within weeks of the amendment's proclaimed ratification, and it is just as good today. 6, against one of the United States. The 11th Amendment bars suits against states and only against states. It doesn't protect cities or counties, or Native American tribes, or federal territories, or the Commonwealth of Puerto Rico. Some of these might be able to claim the common law immunity, probably not the cities and counties, but that's outside the constitutional bar. 7, by citizens of another state or by citizens or subjects of any foreign state. The amendment applies only to suits by diverse plaintiffs against states. The court's gotten that wrong too in New Hampshire versus Louisiana and other cases, which we're happy to discuss more in the Q&A. But the court should be able to separate a sort of anti-circumvention principle from the text of the amendment. So this whirlwind tour through the 11th Amendment's text doesn't settle everything about the amendment's meaning. In particular, it doesn't talk about which state officers or state agencies count as the state. That's something we're planning to address later. But it does clear up a great deal of misunderstanding of what might be the Constitution's most misunderstood amendment. Thank you very much.